eTMA05 is about free movement of goods. And in assessing your answer, we are going to be looking for your ability to define some key concepts, to apply them to the facts, and also to use the common case law of the European Court of Justice. And so if you're answering any question, and of course the three parts of eTMA03 look at different aspects of the area, you need to do a number of things. And the key to it is Article 28 of the treaty, which says that quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. And so, first of all, the question to ask is the particular provision a quantitative restriction? Now, quantitative restrictions are, as the name suggests, to do with numbers. So a certain number of units, a certain weight of products, a certain value of products, limited by number. And of course that number could be zero, it could be a total ban. That would be a quantitative restriction. And if you identify the measure in the question as a quantitative restriction, then it can only be justified by reference to Article 30, and so you'll need to apply Article 30. But assuming that you've decided that it's not a quantitative restriction, could it be a measure having equivalent effect? Or in the jargon of the European Union, is it an MEQR? Now, you're going to need to define what an MEQR is, and of course you have the Dassenville formula. And it's set out in the textbook, and I would certainly urge for exam purposes that you make sure that you are thoroughly familiar with that formula, and I would expect to see it in any question on free movement of goods. So define what an MEQR is and then apply it. The next question to be asking is the MEQR directly or indirectly applicable. Again, we're looking for your definitions and your applications to the problems in the question. If you decide that it is distinctly applicable, then once again the only way that that measure can be saved is under Article 30. If and only if it is indistinctly applicable, then the Cassis de Dijon case becomes relevant, and you can consider whether it comes under the rule of reason, which is that it is required in order to put forward certain mandatory objectives. Again, you'll see it by reading the case of Cassis de Dijon. And any answer needs to be full answer, so if you're going to say that it comes under the rule of reason, you're going to need to point at the particular criteria that is being used. Now, when Dassenville first came in, nobody realised how extensive it would be. But as you'll see by reading the Dassenville formula, it is very extensive and was used by companies to object to regulations which had nothing to do with free movement of goods. And so in recent years we have the Keck judgment. Again, you'll need to explain the Keck judgment, what a selling arrangement is, and apply it to the facts in the question. The other thing that I would urge you to keep in mind is similar cases in your casebook, or the manual itself. So have a look, and if there are similar cases, again, we will be expecting you to make reference to them, applying them, saying whether that they are directly relevant or in fact there are some reasons why they need to be disregarded. So eTMA05 is a practical question. It needs these definitions of the key concepts, the application, and a good range of cases. I would again remind you that if you're going to make an assertion of law, you need to back it up with the proper legal reference. So all the best with eTMA05, and I look forward to doing a short video on the next TMA in a little while's time. Okay, thank you.